morning. My name is Corinne Levy, and I'm currently a second-year law student at the University of Pennsylvania Law School. Today is Friday, March 2nd, at approximately 11 o'clock in the morning. I'm going to be interviewing Bruce Terris in the rare books room of the Biddle Law Library at the University of Pennsylvania Law School. Mr. Terris, thank you very much for agreeing to do this interview. I'm going to go ahead and ask you some questions about your childhood.
Just let me roll for a few seconds to get back up to speed. You can start whenever you're ready.
Mr. Terris, where were you born?
Detroit, Michigan.
And where did you grow up?
I grew up in Grosse Pointe, Michigan.
Is that far from Detroit?
I lived 1 block from Detroit.
And where were your parents from?
My father was from Detroit, and my mother, came from Canada.
What did they do?
Well, my mother was a nurse until she got married, and my father was a doctor.
Did you have any siblings?
I had a brother and a sister.
Growing up with a nurse and a doctor, did you ever aspire to be a doctor?
I intended to be a doctor, and in my junior high school, you had to write a paper on what you intended to be, and I wrote a paper on becoming a doctor, and as part of that, I went to watch my father perform surgery, and when he was finished with that, I didn't want to be a doctor anymore.
Why was that?
It was a little bit too much blood and guts.
Did you ever consider law as a child?
Not really. I don't know exactly how I ended up in law. I think it was in some ways a matter of elimination from being a doctor. Like a good Jewish child, at least in that era, going into the professions was seemed to be the only route possible, and so I guess law came next.
You were raised in a Jewish home. Was your family observant?
No. Very, very Jewish and very non-observant.
Did you have any role models or mentors during your childhood or adolescent years?
Mentors, not really. Maybe my father.
Where did you go to high school?
I went to Grosse Pointe High School.
What was your fondest memory of your high school time?
Well, that's a good question. I don't have a kind of an individual memory of some particularly great event that occurred. I enjoyed going to high school. I enjoyed studying.
How did your time growing up in the 1930s, how did that shape your view of the world?
I don't think growing up in the 30s really shaped it at all. First of all, when the 30s ended, I was 7. And so I can't really remember being very affected. I was very affected by World War II. My father was in the Army, and I traveled all over the country. Our family traveled all over the country with him. And I was very conscious of World War II. And so I'm sure that affected me. But I think what affected me much more is sort of the ideals and values of my family more than what history was going on.
Did you consider yourself going to the Army?
I was too young. The first time I could have gone into the Army would have been in the Korean War, in which I was called in for the draft, and they said I was too blind to be taken.
Wow. You chose instead to attend Harvard University. What made your decision to go to Harvard?
Well, that's in a way kind of an interesting story. In my high school at that time, it's not like today where everybody considers all kinds of different schools and everything. If you got very good grades, you went to the University of Michigan, and if you got a little less grades, you went to Michigan State, and a little less than that, you went to another set of schools, and it was virtually automatic. I was going to the University of Michigan. And a patient of my father's came in and said, "Where's your son going to school?" He knew I'd done quite well. And my father said, "He's going to the University of Michigan." He said, "You know, the best school in the country is Harvard." My father said, "Oh, is that right?" So I applied to Harvard, and I never saw it. First day of school, my family dumped me off at Harvard, and that was the end of it.
And did you enjoy your time in Harvard?
I loved it.
What did you major in?
History and American history, particularly American history.
And by this point, were you intending on going to law school?
Yes, and I think probably I really decided to go to law school during college. And again, I really didn't know even what lawyers did hardly. I mean, students today are so much more sophisticated than I think students then, and certainly that I was. But I decided I was going to change the world and go to law school.
And what activities are you involved in at Harvard?
Not very many, actually. I can't even, the things I did a little bit of charity work, not very much, a little bit of political work, not very much. I guess one should apologize these days, people don't, but I just worked. I worked plenty hard.
You decided to stay on at Harvard for law school. Did you consider any other law schools?
No.
Can you recall the admissions process then?
Well, I had considerable confidence that I was going to get in, and so the only process that I knew about is I filled out the form and submitted it. That was it.
The first year of law school is said to be the most stressful. How do you remember your time as a 1L?
It was very stressful because I essentially had been persuaded. I don't know if they do this with law students anymore, but I'd been persuaded that this, despite having done very well in college, that this was enormously different and enormously more difficult. And I can remember the dean in the first meeting saying, look to the left of you and look to the right of you. 2 out of the 3 of you will not be here at the end. Then he said it was a joke, that's the way it used to be in the 30s, but it was no longer that way in the 50s. But he intended to make one feel not too secure. And I was very insecure through the whole time period. In class, there always seemed everybody else knew more than I did, and that I was very frightened to volunteer. In fact, I never did. I think to the best of my knowledge, I never volunteered once in the entire time I was in law school. And I did very poorly on the mid-year exams, which were graded by, not by the professors, but by third-year students. And I was frightened throughout the whole process.
Well, you made it onto the Harvard Law Review, and you served as article editor. How was your law review experience?
Oh, I enjoyed that very much, and I thought it was probably the most important experience, I think, in mind training that I ever had. It was, I think, a tremendous intellectual experience, but also enormous amount of work. I mean, I worked at the Law Review, the second and third years I worked at the Law Review. Classes stopped roughly at noon. I worked at the Law Review until 10 or 12 at night, and I did my classwork from there until 3 in the morning. I felt under enormous pressure.
Wow. Were you enjoying law school?
I liked it a lot.
That's
not considered, I guess, also. People tell me today, all the problems of law school, but I thought it was a wonderful experience.
Did you have time for any other organizations or extracurricular activities?
Not in law school, except for the Law Review, of course.
Can you recall what you wrote your comment on?
Yeah, it was a boring subject that had to do with corporate law, and I can still remember the professor that reviewed it saying to me, Mr. Terris, when I've read your note, it was called a note, I don't have the feeling that you really know much about this subject. And he may very well have been right.
Are you in touch with any of your law school classmates?
I don't think I am, actually. I'm trying to think about that. No, I don't think so.
At what point during your law school career, or if not during law school, at what point before, did you know that you wanted to do public service work? I'm
not really sure about that, but my last year, I didn't want to do, I had no idea public interest law. In fact, essentially there was no such thing, so I don't think it could have crossed my mind, and it didn't cross my mind. I wanted to do public service work in the very broad sense, and that was that I wanted to work for the government. And I did go to work for the government, but it was, again, the amount of knowledge I had in comparison to what law students have today about what the alternatives are and the amount of exploration that they do. Mine was just total ignorance in comparison to what people know today.
Immediately following law school, you went to work for the Internal Security Division of the Department of Justice. Can you discuss that experience?
Well, a lot of my liberal friends think that's a horrendous blot on my record. The Internal Security Division handled the cases involving communists in the United States. And I was only there a year, and I think I argued a case or two and did a lot of briefing. But I was interested in it because I wanted to do work that had to do with constitutional law. There wasn't a civil rights division that didn't exist at the time, at that time, and so that seemed the closest to what my interests were.
And at this point, it's already the late 1950s. How did some of the political and social issues facing society during that time affect you or your work, your career?
Well, in my work, it didn't affect me a lot. Soon thereafter, I started doing work on the street in low-income neighborhoods in Washington. My wife was a social worker, and she worked in a settlement house in a low-income neighborhood, and she recruited me to work in that. And over the next, I guess, 6-7 years, we developed a whole project in a low-income neighborhood, working the street, not doing legal work at all.
What kind of work did that entail?
Well, we organized a block club. We went door to door in one block, which doesn't sound like a lot of people, but in a low-income neighborhood, it's an awful lot of people. And then that evolved from a block club and a lot of tutoring and other activities involved with that into starting a corporation to provide low-income housing. We started buying houses in the block and fixing them up. And that's the kind of work we did for a number of years.
Did that prompt you to serve as the co-chairman on the National Conference of Law and Poverty? Was it that experience?
Well, that's how I got an interest in it, and it's also why I was asked. A friend of mine who served with me, worked with me in the Solicitor General's office, had become the Deputy General Counsel of the Office of Economic Opportunity. And suddenly, they were going to run the conference, which ended up starting the whole legal services program for the poor. I had no connection with it. But about 3 months before the conference was to be held, the people that were going to run the conference and put it together had a terrible falling out with the Office of Economic Opportunity. Well-known people, the Kahns, who had enormous influence on starting the whole legal services program. They were gone. Sergeant Shriver desperately needed somebody to do something about it, and I got a call one weekend that said, will you run it? Which I didn't want to leave the Solicitor General's office, but I thought it was very important to run this conference, and I said I would do it. And unfortunately, the Solicitor General said he wouldn't keep my spot for me, and that was the end of my career in the Solicitor General's office.
Wow.
So I'm just going to ask you to pause for 1 second and get some reflection from here, so I'm just going to close them.
You okay?
What was it about that opportunity that made you leave the Solicitor General's office?
Because I was very interested in doing something for poor people, and I knew starting a legal services program for the poor was going to be of immense importance. And of course, it's turned out to be of immense importance.
And how long did you continue with that type of work?
Well, the conference took, I think, if my recollection is correct, about 2 or 3 months to put together. It was, and after that, then the Sergeant Shriver decided that based on that conference, they'd put together a program for starting legal services programs all over the country. I worked somewhat on that over the next few months. I had hoped to run that program. I think they thought I was too young to do it, and I didn't get that job. And so in a few months, I've forgotten, I may have been there in total about 5 months or 6 months at the Office of Economic Opportunity. I left.
Did you consider going back to the Solicitor General's office?
Well, I really didn't have an offer, and I don't know whether my career with Archibald Cox, who was the Solicitor General, was not entirely peaceful. I'd had a very large dispute with them over the cases involving one man, one vote, which were of immense importance to the country, and I'd had a deep involvement in it, and he and I had not seen eye to eye on it, and in many ways I'd been successful and he'd been unsuccessful.
How was that?
Well, let me give you a little history that I think you'll find worthwhile going through. The Supreme Court had taken the position in terms of entering into what was the thicket of reapportionment, that it was a political issue and cannot be decided by the courts. In the Eisenhower administration, J. Lee Rankin, then the Solicitor General, decided that the government would participate in Baker versus Carr and would urge that the Supreme Court take jurisdiction of the area. It was a very liberal position and a very valiant position for Rankin. By chance, I was the person who did the actual work in the Solicitor General's office. The Supreme Court did not decide the case and asked for re-argument. It came up in the Kennedy administration. Again, I continued to do the work for Archibald Cox. Archibald Cox never believed in it. It's strange because if you look today at his, he now says in a biography of him, these are the most important cases that he ever participated in. But he was not happy with Baker versus Carr, and when he walked out of the argument, which he gave, he said to me, Felix Frankfurter is right. Felix Frankfurter was the most vehement opponent of granting jurisdiction. A strange thing for an oral advocate to do, walking out of their argument. Baker and Carr was won. Felix Frankfurter did not prevail. And then the issue became how you'd reapportion the legislatures, how would you reapportion Congress and the state legislatures. Again, Archibald Cox was not for a very strong set of decisions by the Supreme Court. The congressional case he cared little enough about. So though I was, I believe, probably about 30 years old at the time, or 31, I argued it for the federal government, which is unimaginable, other than I don't think Mr. Cox thought anything of our position, didn't like our position. I won, and the Congress was reapportioned. The state cases, however, were in many ways the most interesting. Cox did not want to go to one man, one vote. John Kennedy, before he was president, had written an article about the importance of one man, one vote. I wrote Mr. Cox a very, very detailed 15-page memorandum, single-space, in which I said to him that I thought was rather bold, that I didn't think it was an issue that should be decided by the Solicitor General's office, that it was not ultimately a legal decision, it was a political decision. He, to his credit, I think to his credit, was sufficiently impressed by that argument to take the argument and to give the memorandum to Robert Kennedy. And there was a very big meeting in Robert Kennedy's office with all the top people in the administration other than the president, the top political people, the top legal people in the administration, to discuss what position they would take as to one man, one vote. And Archibald Cox argued vehemently the Supreme Court would never buy one man, one vote. And at the end of the discussion, Robert Kennedy said to him, "Archie, you can figure out a way." And he walked out of there, and I walked down the hall to our offices with Mr. Cox, and he said to me, "You know, Bobby doesn't understand this." And I thought to myself, he understands well what he's doing. Archibald Cox was a very great man and a great Solicitor General, had a very big ego. And just as Bobby Kennedy had figured out, he would figure out a way to come out for one man, one vote. And he did, and one man, one vote prevailed in the Supreme Court. But I'd had quite kind of a rocky situation with Mr. Cox, and that's sort of, I think, the explanation of why I never went back.
Wow. You argued a whole bunch of cases before the Supreme Court, I think 16, and you've partaken in 70 other Supreme Court briefs. Can you describe the first time you argued before the Supreme Court?
I can't remember very well. I'm sure I was petrified, but I have found sort of in the things I've done in life that the things that most people think are very, very scary, I've been scared, but the minute the adrenaline flows, forget about it. And I can't think about it anymore. And there are other things that I've done in life that the whole rest of the world thinks, why would anybody be frightened by them? And I am frightened all the time.
Is there any particular case that you've argued before the Supreme Court, or any particular experience that sticks out in your mind?
Well, certainly the most important case I've ever argued was Westbury versus Sanders, which was the congressional reapportionment case. It's probably one of the more important cases the Supreme Court has ever decided. But I've also, in the environmental cases that I've argued in private practice, I think have also been awfully important to me.
Was your memorandum or your connection with Senator Robert Kennedy what led you to work on his campaign staff?
Well, I became a friend of his. It's a funny thing being a friend, in the sense I never was invited to a social occasion at his house. But on the other hand, I know because he told people that he considered me a very good friend. And I once tried to figure out how many times I'd actually seen him, and I think I may have been 10 about. But from the day he first walked into my office at the Solicitor General's office, because when he became Attorney General, he decided to go through the building, walking into people's offices. And one day the door opened and he was standing in my office. And he said to everybody that he saw, if you want to talk to anybody, come and see me. So I did, because I wanted to get him to come down to our block project in the low-income area. And he did. And so in a variety of different ways I came to know him. But the main reason was that I helped him prepare for his only argument ever in court, the only time he ever appeared in court, which was in the Supreme Court. And so I think that was the time I probably knew him the most, that work.
Wow. And how...
A few seconds. And if you want to go back to what you were just talking
At what point did you decide to work on his campaign staff?
Well, I'd actually been working for the previous year for Hubert Humphrey as in his office, and I'd been asked to do that actually by the White House. I've forgotten which year it was that they expected rioting all over the United States, and I was supposed to work on preventing a riot in Washington. And so I did a lot of work in trying to get young people jobs and and set up recreational programs and the like. And then I continued to work for Hubert Humphrey. I, of course, thought, like the whole rest of the country, that Robert Kennedy was not going to run for president. And so I just continued to work for Vice President Humphrey, and then all of a sudden one day Robert Kennedy was running for president, and I called the Vice President's office and said, I'm quitting. And I went to work that day for Robert Kennedy for president, and there was a little squib that next day in Drew Pearson's column saying that somebody from Vice President Humphrey's office, Bruce Terris, had left that office to go to work for Robert Kennedy, which of course had a little bit of jazz to it, in the sense that, because obviously what they were interested in, press was interested in, was what kind of a movement there would really be towards Kennedy.
Well, at this point, you're yourself quite young in your career. You served as a co-chairman on the National Conference. You also served on the National Crime Commission. You worked on matters related to minority business, organized a block party. What is pulling you to all these public interest affairs?
Well, that's okay. Okay, I'm going to have to back up a little bit. Part of it was the work I did on the street. I mean, there's no question about it. Part of it was my wife's deep interest in social work. I guess that I'm going to have to go into a personal thing to tell you. As I indicated before, my family was very non-observant, totally non-observant Jews. I picked up a very liberal background from them. My father we lived in a community, Grosse Pointe, Michigan, which was as solidly a Republican community as you possibly can get. I remember they had a poll between Roosevelt and Dewey in my grammar school, and it was 90% for Dewey and 10% for Roosevelt. Now you can, since Roosevelt won in a landslide, you can figure out that this wasn't very representative of the country, this community. But my family are Jewish, and almost all Jews in the country are Democrats, and they were New Deal Democrats with enormous feeling for what Franklin Roosevelt had contributed to Jews. That had an influence too. You asked before about mentors and role models. I had essentially never seen a Jew who was religious in my entire life. I didn't know any Jews in Grosse Pointe because there were none. 75,000 people, I think there were 15 Jews. At Harvard, I knew lots of Jews, but none of them had any interest in religion. I developed an interest in religion, and through girls that I went out with, I guess. And my first wife was a Catholic, and I became a Catholic. And she was very, very deeply committed to social issues, and I was very, very deeply committed. I gradually became less Catholic, but I did become less committed to social issues. And my wife died suddenly, tragically, and at that point, my second wife said to me, who was born a Christian but not a practicing one, said to me one day, why aren't you interested in finding out about Judaism? And I said, well, that's an extremely good question. Okay. She said she would go with me, and we would go to some classes, and I said I'd start reading. And today I'm an Orthodox Jew. In fact, I've been an Orthodox Jew for 20 years. And, but I guess the constant throughout the whole process is that I have always believed very deeply in a combination of both religious and liberal values, which to me are very, very closely connected.
And did your wife convert?
She never converted.
But she practices as well?
She doesn't practice Judaism, but she keeps a kosher home.
Wow. What brought you to Orthodoxy as opposed to
Other
more
things?
conservative or?
Well, I first went into a Reform synagogue, and seemed like the place to start because that's the synagogue that my family always belonged to, although they almost never attended. And it was totally uninteresting to me. The rabbi was talking about political issues. I didn't really need to go to a synagogue to talk about political issues. I had plenty of that, and I like political issues. I'm a fanatic on political issues, but that is not where I wanted to find out about them. And so then I went on to conservative, that I didn't stick around for hardly any period of time. I did start at a conservative Havurah, and in many ways that was the most important event how I got to Orthodox Judaism, because that's how I began to learn about Judaism and go to synagogue regularly. But then I decided that I just moved, and unlike people that have suddenly become born again, I just moved in very, very small stages. I mean, I started out, I stopped eating pork. I stopped eating shrimp. I went to synagogue every Shabbat. Then I stopped eating meat and dairy together. All the kind of various things, but in very small stages. It took several years. And I just kept moving, and I kept doing what I thought was the right thing. Then finally my wife said to me, "Why do you live in the United States?" And I said, "Well, what do you mean?" Well, so we took a vacation in Israel. It's the first time I've been to Israel. And she said, "Why do you live in the United States? You purport to be an Orthodox Jew. Or you're becoming a..." And at that point, I'd actually become Orthodox. Right at that very point, I'd become completely Orthodox. And I said, "Well, I don't know. I mean, would you be willing to move to Israel?" And she said, "Yes." So we moved to Israel. And I actually live in Israel today. I consider myself living in Israel, not in the United States. I live in Jerusalem. And although she now spends most of her time in the United States, and I spend half my time in Israel and half the time in Washington.
How do you manage with your firm?
Well, if I weren't the senior partner, you couldn't do it. But with modern communication, you can. I mean, I work every day in Israel. I get anywhere from 10 to 100 pages of material every day. And I work, and I use the telephone, and I talk to people, and I make sure I'm back in the United States when it's time to go to court.
Did you ever find at any point throughout your career that being Jewish and then becoming Orthodox affected you negatively? Or did you ever experience any discrimination at all?
Not that I know of. I mean, a couple of times in my life somebody has made an anti-Semitic comment to me, but not actually not very much. I can't, even in Grosse Pointe, which certainly if you'd find a place at that time to be anti-Semitic, you would have, because at that time Jews were not allowed into Grosse Pointe. And I know the only reason my family got into Grosse Pointe is because Terris can't be identified as a Jewish name. So it was not a welcoming place for Jews, but I never felt really any problem. There's more, if you want to find a place where there's more antagonism to being an Orthodox Jew, it's in Israel.
Why is that?
Because unfortunately in Israel we have a great culture war going on between religious Jews and secular people.
Wow. And you served as a visiting professor of law at Catholic University. What did you teach there?
Constitutional law.
Did you enjoy it?
Yes, I liked it a great deal, and I thought a lot about being a law school professor. There were a couple of places that were interested in hiring me. I mean, they didn't make offers, but they were interested. But I decided that it was too divorced from the real world. spend my entire time in law school. I love teaching students, but I didn't know that I wanted to do it all the time as a full-time job. I honestly can tell you I was very good at it in the sense as a teacher. I don't know that I'd be a good law review writer. I was voted the best teacher the year I was there. And because I have an ability to sort of engage people when I'm talking. I'm not exactly sure what idiosyncrasy does that, but I do have that ability. And it's the same ability I have in court, because a judge can say nothing to my opponent when they get up, and somehow when I get up, I get 100 questions in a row. It's some peculiarity of my personality.
It's often said that a teacher learns as much from his students as the students learn from the teacher. Did you find that to be true in your experience?
I would say yes, but only in a funny sense. I don't think students learn as much from the teachers as they learn from other students. And so in that sense, maybe I did learn as much as they learned from me, but that's because I'm not sure I was teaching them that enormous amount. I think to a great degree what you learn at university, both at undergraduate and graduate, is the interaction with other students. People that don't spend time around other students because they live at home or what have you, I think lose an enormous amount.
One thing that I've found personally in my legal education particularly in my constitutional law class, was that professors are often unable to divorce the way they teach and approach the material from their own kind of political views. Having such a strong democratic identity and a strong commitment to public service, do you feel that that flavored the way you presented the constitutional law issues?
No, I'm almost sure I didn't. First of all, I used entirely the Socratic Method. I believe very, very strongly in the Socratic Method. I was taught that way in law school by marvelous professors, and so I used the Socratic Method entirely. I would doubt that I ever said more than a sentence that described what I thought on any subject. In fact, my tendency in teaching was to take whatever position the student had and essentially ask questions based on contradicting it. And so, no, I don't think it would have been, I think, you might have been able to figure out that I was a liberal after all, a student that sat there for a whole year probably could have figured that out sooner or later, but you wouldn't have gotten in a very direct sense.
What is it about the Socratic Method that you believe in so firmly?
Because I think it's a way of pressing people to think. And to me, law school has very little to do with what you learn. The substance of what you learn, you can learn that. A good law student can essentially learn any subject, I think. They should be able to. But what I thought was extraordinary in law school was changing the whole way I thought. My whole intellectual process was changed in law school. And I don't know if I was successful in doing the same thing for other people, for my students, but that's what I was interested in.
Did you consider going back the following year?
Excuse me?
Did you consider teaching again the following year?
I really didn't. I sort of thought, well, I certainly wouldn't have continued at Catholic University. I would have, it's not at the top rung law schools, and so I wouldn't have done it there. But I never really felt comfortable in making a life of teaching. As I say, I really thought that wasn't what it didn't really fit my personality quite right. Much as I love teaching students, it didn't really fit my personality. And I particularly don't like that kind of politics, which I know exists very, very prevalent in academia. And I don't like that at all.
Having had so much experience before the Supreme Court, were you able to invoke a lot of your own experiences with the court in teaching constitutional law?
I didn't do as much of that as you might have thought. It's interesting. You ask an interesting question. I really taught the casebook to a very large degree, and for the most part, I'm not sure any of my cases were in the casebook that I'd argued. I don't think they were. I don't even think Westbury and Sanders was. So I did not. I did not. Basically, a lot of professors I know, war stories are a big part of their. Of what they talk about. I didn't do very much on war stories.
Shame, because you have a lot of experience. And after all this government work, you went into private practice. What prompted that transition?
Well, it was going into public interest law. The public interest law movement was just beginning to start at that point. There were the old line ones, the ACLU, the NAACP, the Legal Defense Fund, but essentially there was no law, public interest law in the country at the time. A group of people began to meet in Washington, a very small group. I can't remember most of the people in it. I do remember one who certainly is famous, and that's Judge Patricia Wald, who later became a judge, a Court of Appeals judge, very distinguished one. And she was part of it, and Charlie Halpern was part of it, and there were a few other people, and the thought was that we're going to create a public interest law firm. The Ford Foundation was interested in putting out money into public interest law right at the very beginning. And so we met, and then finally Charlie and I put together a proposal for the Center for Law and Social Policy, and we got it funded by the Ford Foundation, and that's how I got into real public interest law. Then, unfortunately, the Ford Foundation was under intense pressure in Congress for its liberal funding, and there was a lot of talk about it was really engaged in politics. And then they came to me and they said, you, Bruce Terris, and I was the chairman of the Democratic Party at the time in the District of Columbia, and they said to me, you either have to quit as chairman of the Democratic Party or you have to leave the Center for Law and Social Policy. Well, I didn't like either alternative, but I had to do one or the other. So I quit the center, and I still wanted to practice public interest law, so I set up my own. I went out by myself and said, I'm going to be a public interest lawyer.
Can you talk a little bit about your experience as chairman of the Democratic Party?
Well, I became chairman. I had never been really in politics. I quit Humphrey's staff, went to work for Robert Kennedy. I certainly didn't do anything terribly important. I worked on his speech writing group, but I never wrote a speech. He had two fantastic speech writers, and all I and a few other people did is junky research. Then, of course, he got assassinated. Before he was assassinated, the slate was put together to run for the Central Committee of the District of Columbia, the Democratic Central Committee, and for delegate. And they were looking for people to put on this, and for the Democratic Central Committee, they decided they put me on. I knew a lot about Washington. I'd worked the street, what have you. And so they put me on the slate. Well, again, it had nothing to do with me. Robert Kennedy, anybody, a 2-year-old would have been elected running with Robert Kennedy in the district that year, and we won overwhelmingly against a slate pledged to Hubert Humphrey. Kennedy was assassinated. I was on the Central Committee having won, and my friend Channing Phillips, a very fine black leader who was the Democratic National Committeeman, he'd just been elected, wanted me to become the chairman. So since he was influential, I became the chairman. Again, it had nothing to do with me. I couldn't have beaten anybody other than his having supported me. But we became then very, very active. The Central Committee became very active. We did not have home rule, so we, in effect, acted as if we were the representatives of the people of the District of Columbia. And as a result, we did an enormous amount of things, taking on the racism in the police department, taking on the welfare system, doing things in schools. And so I was on television a lot, and I was on a lot of things that came during that period. I went after the police chief for his racism, and they even asked Lyndon Johnson about it at a press conference, and actually shortly thereafter the police chief was dumped. And so I felt like I'd actually accomplished a little bit. But it was fun, and that's essentially my political career, those 4 years.
And how did you balance it with your private practice once you had gone out on your own?
Well, I just worked hard. So.
And have you enjoyed private practice?
Yes, I enjoy public interest work very, very much, and it just kind of grew. I mean, again, without any real planning. I had no environmental background, but one of the people that formed the Center for Law and Social Policy had left to become the head of the Sierra Club Legal Defense Fund, and he thought I was a good lawyer, and in the 70s, he essentially brought me all the most important environmental cases the Sierra Club had. And so there were no environmental lawyers in the United States. There were literally no environmental law courses in the United States. I believe there was not a one. And there were no environmental lawyers. And so the result was my little office, which was gradually growing, started doing environmental work across the country, Florida to Alaska, all across the country. We did mainly for the Sierra Club, environmental work. We blocked development of 50 million acres of federal land in a case in San Francisco. We stopped clear cutting in West Virginia, which resulted in a new statute by Congress to limit clear cutting in national forests. We won the significant deterioration case that protects areas on air quality that are relatively clean, and you can find in the Clean Air Act today elaborate provisions for that came out of our lawsuit. It was very exciting, and we were basically the only people in town.
The last case that you mentioned about the Clean Air Act, is that the Friends of the Earth case?
No, that's Sierra Club versus Ruckelshaus House that the Supreme Court decided our way by a 4-4 vote.
Wow. So you kind of fell into environmental work, sort of.
I just fell into it. I'm not even, by environmentalists would regard me as atrocious. I mean, I think I've taken a decent hike once in my life. But I value the environment immensely. But I'm not a canoeist. I'm not a hiker. I'm not any of those things that all true believers are.
The Friends of the Earth case, that was a recent cutting-edge case that made its way up to the Supreme Court. Can you talk a little bit about that case and explain your role in it?
The Laidlaw case for the Friends of Earth?
Yeah.
Well, we do in our office an enormous amount of work enforcing the Clean Water Act. Our practice, let me just explain a little bit. Our practice has shifted very dramatically. In the 70s, we were hired by environmental organizations. They paid us by the hour. They didn't pay us a lot, but they paid us by the hour. By the 80s, these organizations had developed such large staffs of their own, and there were so many people in the country who now had gone to environmental law courses in law school and wanted to do environmental work for free. They very frequently practiced law commercially for big law firms and what have you, but they wanted their ideology. They'd love to have one case in their lives in which they were on the right side. It became competitively impossible for us to continue to do that work because pretty hard to compete against people that are working for nothing. And so even though people would prefer to have us handle it, we had vastly more experience, that work entirely dried up. Sierra Club stopped hiring us. NRDC handled its own cases, etc. So if we were going to continue environmental work, we essentially had to represent ourselves. And we went out and found our own cases, Clean Air Act cases, Clean Water Act cases, in which nobody paid us, and which we would be paid only if we won under the fee-shifting statutes. The Laidlaw case was one of those cases. We have probably brought close to 100 Clean Water Act cases in pretty much all throughout the eastern United States. And we fought that case. It's a very interesting case in a lot of ways, not just legally. We fought the case through the courts over a period of about 8 years. The amount of money we had in it, our investment, our actually out-of-pocket investment was probably about $150,000 to $200,000 that our law firm fronted. Ultimately, we lost in the Court of Appeals, the Fourth Circuit, in the district court on standing grounds. It was affirmed in the Court of Appeals. We went to the Supreme Court. We got certiorari, and we ended up winning a very, very big victory on standing that is going to have a major impact on environmental cases all over the country. I want to give the one last thing about it because it shows the hazards of public interest law. Having won it, and almost certainly having then going to be able to enforce the judgment and get attorney's fees, since we already had in the district court a judgment in our favor, which would be reinstated on remand. Laidlaw, even though it was a Fortune 500 company on the New York Stock Exchange, declared bankruptcy.
Oh, no.
And we have pending a $2 million attorney's fee application, which it's very possible we will never see a penny of.
Wow. Justice Scalia has been somewhat resistant to private suits brought by citizens to vindicate
Delicately put.
the public impropriety. As far back as 1983, he referred in an article to the, quote, constitutional impropriety of the judiciary's long-lasting love affair with environmental litigation. How do you view his role in the restriction that the 1980s have shown on environmental law?
Well, for the most part, the Supreme Court has done little in environmental law, and I think that's probably been a good thing, because whatever they would have done would have probably been hostile. Most of their cases have been decided against environmentalists, with a very notable exception of 2 days ago, in which Justice Scalia wrote the opinions, interestingly enough. In the area of standing, however, both environmental and others, it is very clear Scalia has been running a major campaign. In my opinion, he is one of the most activist judges that there has ever been on the Supreme Court, and it always amuses me when, maybe amusement is not quite the right word, when conservatives say that Earl Warren and Douglas and people like that are activists, but of course no conservative has ever been an activist. Well, if there's ever been an activist Supreme Court justice, it's Scalia. All one has to do is read his standing decisions. They are a whole campaign of how to limit the federal courts to not handle essentially public interest issues, not just environmental, but across the board, and to narrow them down. And he wrote a law review article when he was on the Court of Appeals that explicitly says that you should have very narrow standing for public interest people, but you should have broad standing for corporations. I mean, it's such a remarkable argument, and it's on the ground that corporations are a minority, but the public interest people are a majority. Therefore, the Congress pays attention to public interest people and doesn't pay attention to corporations. I don't know what world exactly one has to be operating in to have those views. So he's been running this campaign, and it's an interesting campaign because the truth is there is no support in history for the whole standing doctrine. The standing doctrine is essentially judge-made in this century. And if you look at the history of the courts in the Anglo-Saxon world, there was no standing doctrine. And it's been made up by judges who were activists.
Do you believe that he poses a threat to plaintiffs' right to bring suit, having written 4 of the last 5 decisions by the court on environmental issues?
That he's a threat?
Yeah.
I think he's a threat to virtually any liberal cause. I mean, in the sense, and partly, of course, because he's a brilliant man. He's an extremely smart man, and he knows where he's going all the time. I mean, it's not. If you think of the classic situation of a judge, what is a judge supposed to do? It's not supposed to have any program. Other people bring a problem to them, and you are then obligated, responsible to decide. That's not Justice Scalia. He has a program. And other people bring things to him, and he figures out how to put them in this program.
What would you say is the biggest environmental threat we face today?
Biggest environmental threat today? You mean in substantive terms? Or I suppose global warming would be the biggest threat. But when you ask me a question like that, it's interesting. In many ways, I'm a lawyer. There are many, many other people in this world, thousands of other people, who know much more than I do on what set of priorities there ought to be in the environmental field. I think, I suppose global warming would probably be right.
Well, what do you think is the biggest challenge that environmental lawyers face in the future?
I think the biggest challenge there is enmeshed in the whole American political situation today, which I think is essentially quite unfriendly to the kind of things I believe in, the liberal things I believe in, whether it's the environment. I think it's much more serious in terms of poverty. It's serious in terms of racial relations. I think the trend in the country has been very bad over the last several decades, and so it threatens all those kinds of issues that I care about.
And more recently, you were involved in the 2000 presidential election recounting. Can you describe a little bit your role in that?
Well, it's very limited. I mean, well, it was, I guess I would tell you it's both limited and intense. And I suppose it's hard to figure out how it could be both. Like the rest of America, I sat around watching cable television for a month or several weeks, watching what was going on in Florida. Actually, I hadn't done that. That's not quite accurate. The day after the election, I called the Gore headquarters because one of my associates had pointed out to me that the absentee ballot situation in Florida, counting ballots that had been cast that were received after Election Day, was flat out illegal under Florida law, and that everybody was preparing to count those ballots, even though the Florida statute makes it clearly illegal. So I called them up and said to them, you know, this is illegal. And I sent them some material about it. And they didn't do anything with it. And of course, I know why they didn't do anything with it, because politically it was very, very harmful. They would have been cutting off. They were arguing every vote should be counted, and then they would have had to go into court and argue that military ballots that arrived after Election Day couldn't be counted. So they failed to do anything with it. And I kind of mulled that over for about a couple weeks, and then I said to myself, this is ridiculous. We're going to bring this lawsuit. So we found some Florida voters, and we brought a lawsuit, which got litigated in a week. We worked on it, I think, for 10 days. Virtually the entire law firm. We have 9 lawyers, and virtually the entire law firm worked on it completely for 9 days. We went into state court, It got removed the same day to federal district court in Florida. I argued it, I think, the next day in the federal district court in Florida. We drew a very conservative judge. We lost, went to the 11th Circuit, asked for an emergency hearing. But then we drew three very conservative judges, lost, and petitioned for certiorari at exactly the same time that the second Bush versus Gore case was in the Supreme Court. We hoped that what we would be showing the Supreme Court is that our issue put into focus in a very dramatic way the inconsistency of what the Bush campaign was arguing. They were arguing to the Supreme Court in the main case that the Florida legislature, what it had decided in their statutes, had to be followed absolutely with no variation. And even the Florida Supreme Court had no right to do any touching of it. We said to them, okay, if that is true, look at the Florida statute. The Florida statute says you can't count these ballots. The only reason you're counting those ballots is there's a regulation that says you can count them. It's not valid under the Florida statute. And if the Florida statute is sacrosanct, you can't count those ballots. Well, of course, the Supreme Court never didn't grant certiorari. It just delayed. And then after it had decided the main case, a month later it denied certiorari.
What was your firm's interest in bringing the suit?
Well, everybody in my law firm's got the same political views I do. Not that I've ever asked them what their political views are, but who does anything as stupid as practicing public interest law if you're not going to have views of this kind?
Can you comment on the Supreme Court's decision in Bush v. Gore?
It's an atrocious decision. I mean, it's a totally political decision. And, anybody can immediately see it. All you have to do is ask the question. If Gore had been ahead, would that opinion have been written? I mean, the answer to that is absolutely impossible. And do these justices who are so now intensely attuned to the Equal Protection Clause, have they ever cared about the Equal Protection Clause before? I mean, no. And why do you put a sentence in there, which there is in there, a quite amazing sentence which has not gotten nearly enough attention, which essentially says, don't pay attention to this opinion. We do not claim it will be ever precedent again. There is a sentence in there that basically says that. Quite amazing for a court ever to say that it is essentially deciding a case for a one-time event.
Might it have been just because it was such an unusual circumstance that would probably never arise again?
No, that's not the implication. The implication is that you shouldn't take too seriously what we say as future precedent. I mean, it is outrageous for a court to say that, because the whole nature of the judicial process has to be that what you're deciding is precedent, because you're not deciding an individual case. You're supposed to be deciding principles that have some lasting effect.
Mr. Terris, in looking back on your career, having accomplished so much public interest work, so much government work, so much success in your private practice, what do you feel has been your biggest accomplishment, or the work that you're most proud of?
I don't think there's a kind of like an individual. I mean, if somebody said, what was the most important thing I ever did? The most important thing I ever did was working on one man, one vote, and helping to shape what the government's position was. I mean, almost certainly that's true. But my own feeling doesn't really, I mean, I don't really have that kind of feeling of looking back at that kind of thing. I think the feeling I have, my gut reaction to it is being able to run a public interest law firm for 30 years and to somehow make it operate when it's enormously difficult to do it, and have it survive and do some reasonably good things in the process. I think I'm probably most proud of that.
And in looking forward, is there anything you'd still like to do? Perhaps teach?
Excuse me?
Perhaps teaching, you mentioned?
Well, I can't say if somebody offered me a teaching job at this time of my life, I might not do it. But I think the thing I'm most, I'd like to keep my law firm operating, which is no small feat, because it's always in financial difficulty. And it is at this very moment. Well, I shouldn't say always, it has these fluctuations that go on all the time, but it is at this moment. But I think that's mainly what I want to do, and also get a variety of different things to do. You know, people have asked, why do I really practice this kind of law? And I can't really tell you I do it for any great noble reason, because I really don't think I do. The reason I think I practice this kind of law is because it is immensely more fun and immensely more satisfying. If it weren't, I'm sure I'd go do what most lawyers do, is go out and make a lot of money. And so to me, the trade-off on having a very intellectually challenging, a tremendous amount of fun, going up against the biggest law firms, going up against the government, and more often than not beating them, that to me far outweighs not getting paid very much money to do it.
Mr. Terris, thank you so much for taking the time to be part of our oral legal history project. You've had a fascinating career, and we wish you all the best.
Thank you. Thank you. You ask very good questions. No, I'm really impressed, because you hadn't even seen my resume until a little while ago. I'm very impressed. I thought you were you were going to be kind of scratching around, not knowing quite what you were doing. So no, that's very, very impressive.
You have an impressive resume.
Hmm?
You have an impressive